Perfect. Thanks, everyone. Welcome to today's webinar. Today is February 13th, 2025. Our webinar today is Disciplinary Actions Simplified, from Verbal Warnings to Termination, presented by Ethos Human Capital Solutions and Merhab Robinson and Clarkson Law Corporation. My name is Denise Keddy, and I'm your moderator for today. A couple quick reminders we like to go through for every single session. The webinar will be about an hour long. If you have Q&A after the webinar, please put it in the Q&A section that's at the bottom of your panel. We will get to the Q&A at the end. If we don't get to your questions, we'll follow up. We're going to record the webinar today, and you can find the webinar online at both the Ethos HCS YouTube channel and the Merhab Robinson YouTube channels in the next 24 hours, like I mentioned. I will put links in a moment in the chat section once I'm done with the interview. And oh, here you go. Or you can download the slides from this link on your screen right now. But I'll continue to put it in so that in case you missed it, you'll be able to download it. Again, if you have questions during the presentation, post them in the Q&A area on the dashboard anytime. If you'd like your question directed to a specific panelist, please note that when you send that in. That really helps when we go back and look at the questions from 10 minutes earlier. And quick reminder that today's webinar is being recorded and all the materials are protected by copyright. Our presentation today is intended for the information purposes only, and you should not rely on it to reach a conclusion in any area of law. We recommend that you consult with your own legal counsel to address your specific situation to ensure you have the most current information on legal matters. So let me introduce our panelists today. Our legal expert is fairly new to our team, but she's been on the last couple of webinars, so this is we're getting into a good flow with her, is Luna Hernandez. Luna is an associate attorney at the law firm of Merhab Robinson and Clarkson in the firm's transactional department, where she advises clients in real estate finance, M&A, and most importantly to today, employment law. She joined the firm in February 2021 as a transactional department paralegal after immigrating to the US, so you'll notice her beautiful accent, and she was admitted to the bar in November 2023. And recently, she was elected to the Orange County Bar Association Young Lawyers Division Board of Directors, where she serves as co-chair of the Education Committee. Congratulations, Luna. And if it doesn't keep you busy enough, she has a baby, a little beautiful baby boy. So she is a busy woman. So thanks for the time. Our next presenter will be Linda Duffy, president of Ethos Human Capital Solutions. Linda has over 30 years of human capital experience and has built her business and team to deliver outstanding consulting, recruiting, training, payroll support, and organizational program results for your clients. Linda and the Ethos team are known for building the magic of the human connection with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization, so that you, as a business owner, can focus on the act of growing your business. In Linda's spare time, you can still find her cheering on the Angels, because I know she's counting down to the first day of the season, even when they have a bad season. But she's a diehard fan. Linda, can you get us started this morning?
I can, and right now it's duck season, so that's where my focus is. But yeah, thanks, Denise. Welcome, everybody. Thanks so much. This has obviously been a very popular topic because we had quite a few people register. So we'll do you justice on that. And as Denise said, as you have questions, just drop them into the Q&A section there. For those HR professionals that are certified through HRCI, we do have this program approved for 1 hour of general HR credit. And so you can take down this number, but in order to get your certificate, I need you to take this survey afterwards. So we'll also have this link in a follow-up message that you get through Zoom. And I would appreciate if everybody would take the survey. But if you need a certificate of attendance, you definitely need that. If you are certified through SHRM, you can still get credit for this. You just don't have the handy number that will pre-populate everything in their system. But you can still get credit for this under SHRM as well. As far as our agenda, we're going to go through and sort of talk about the things that you might expect, right? Going through all of the basics of disciplinary action, through terminations, talk a little bit about progressive discipline, talk about some other concerns you might have. Just one caveat to this, we are not talking about collective bargaining agreements or unions. So if you do work in a unionized environment, I apologize, but all bets are off with you because the CBA is going to control a lot of this. But for everybody else, it doesn't matter if you're in California or any place else in the country. What we're going to talk about today is going to give you some insight. So let's start by talking about alternatives to discipline, because I think it's a natural go-to if somebody violates a policy, and certainly if there's a more egregious violation like theft or something like that, your automatic response is going to be, let's go write that person up or let's go fire that person, depending. But I think the first step in this process is really to think about, is this a disciplinary situation or is there an alternative that might be a better solution? So for example, does this employee need more training, right? Like you recruited this person and presumably they had the right skill set, but do they need additional training? Are they fairly new and they're not trying to not meet your expectations, but they're having, some sort of challenge understanding the information or some coaching or something like that. Every once in a while, and this isn't something that we would lead with for sure, maybe it was just a bad fit for them. Like you love their attitude, you love their cultural fit, but they just aren't going to cut it in terms of meeting the position's requirements. And so maybe moving them to another position does make sense, right? Again, we don't usually lead with that because we don't want to transfer a problem. So if it's a person with a bad attitude or someone that's, can't ever get there on time or something, those aren't the people you want to even think about moving to another department. But it could be that for whatever reason, this just wasn't a good fit. You found that out after they started. And maybe just moving them to another role might make them successful. Same thing about having a different manager. Again, if the manager is the problem, then that's a different story. If the employee is having struggles with that manager, every once in a while, it makes sense to at least ask the question, right? Instead of just rushing into let's start documenting things and trying to move this person out. So don't transfer a problem, but take a look at those alternatives to see, okay, do we really want to go down that road of discipline, or is there another way to save this person since we've already invested a lot of time and effort into recruiting and training and onboarding them? And then the next thing I would say is before any of this starts, you need to be really clear about your expectations. I can't tell you the number of times that we've had conversations with clients, where the client's like, they're not doing something. And then you talk to the employee and they're like, I didn't even know that that was a requirement or an expectation, for me. So make sure that you're clear about your company's expectation, the job role expectations, what your manager's expectations are. So the way it may show up, for example, certainly from a policy violation type standpoint would be if you have a handbook and you have standards of conduct in that handbook, that pretty much outlines what your expectations are, the thou shall nots, right? Um, Probably in your handbook, you have an attendance policy. You certainly have at will language if you have that. Maybe your offer letter, you have job descriptions. There's so many different ways that you can set forth expectations. Onboarding, orientation, hopefully that's part of that conversation that you're having, performance reviews, all of these different ways when you bring somebody on board, are great ways to at least set that expectation up front, so they know sort of the rules of engagement, right? Well, if I come to work here, I know I have to be at work from 8 a.m. to 5 p.m., things like that. Okay, so let's go on and talk about just some disciplinary at a high level, right? Disciplinary alternatives. So I'm going to use the phrase progressive discipline, but I'm also going to give you another sort of caveat there. So progressive discipline is really just a system to move people throughout the process from verbal warning through termination, unless, the discipline turns their performance around, right? So I will say though, that there are times when you're not going to go exactly in this order, right? And it really depends on what is happening with the employee. So here's an extreme example. If an employee walks in and says, I've got a bomb, or I've got a gun, or there's something going on like that, you're not going to sit there and say, well, I'm going to issue you a verbal warning. You shouldn't bring a bomb to work. Like, no, you're going to be calling the police and getting them arrested and everything else, and they're fired, right? So that's one of those where you're going to go straight to termination. There might be other times where you're like, you know what, this is a one and only final warning. It's your first warning and your final warning based on the severity of what's going on. And if they can't correct it in a short time frame, then they're out. But generally speaking, if it's somebody that's just not meeting your expectations in terms of job performance, you're going to start with maybe a verbal warning and then progress to a written warning and so forth. You just want to make sure that the language in your handbook is not locking you in to doing it that way, right? That you have the language in there that says, we may or may not follow this, right? The other thing I would say is a lot of times clients think, well, if I do it for one employee, I have to do it for all employees. And I say that's not true. It's a great rule of thumb to try to be consistent, don't get me wrong, but it's not true. It is true for similarly situated employees. Try saying that a few times fast. So if you've got an employee who's been with you for 15 years, let's say, they've always had stellar performance, stellar attendance, everything's awesome. And then all of a sudden they start showing up late. I don't know about you, I would think, hey, I really wonder what's going on because this has never been an issue up until now. And all of a sudden, this person's showing up late. Maybe I should have a conversation with them, as opposed to someone who's in their first 90 days, right? Who from right out of the gate can't seem to get there on time. I'm less concerned about having that conversation. I'm going to, of course, try it, but I'm not going to give them a lot of rope to hang themselves with, bad reference, but I'm going to make sure that I don't allow this to continue much longer. So that's just another thing to think about is if you've treated somebody one way and they're similarly situated, then yes, you want to treat them the same way. But look at the circumstances and decide what's the best course of action for that particular situation. So the first step usually in the process is going to be a verbal warning, right? It's going to be a coaching session. Some people call it that. It's going to be, conversation, right? That you're going to have with the employee. I'm going to speak to you all as though you're managers. So, you're going to sit down with your employee and you're going to say, hey, this is what's going on. Expectation, here's you, right? There's a gap between the two. And let's talk about how we can get you back on track. I always encourage people, make notes about what you want to say in advance because these aren't normal conversations, right? Nobody ever grows up having disciplinary conversations. So make notes in advance about what you want to say and just be clear. These are the main points I want to get across. Don't throw everything in the kitchen sink in there. Just make sure you're like, you know what? I really want them to understand that they need to be there on time, at 8 a.m. So I'm going to have that conversation and see what I can do to support them in getting there on time, right? You want to always meet with people in private when you're having these conversations, unless you want a witness present. At this stage, I don't know that a witness is necessary. You want to document like on your calendar by sending yourself an email, sending an email to HR if you have an HR department that, hey, I had this conversation with this person on this day and here's what was said. But you want to make sure that you're getting the point across to the employee that, hey, this is the first step in our process, right? So I really need you to turn this around. And you want to make sure that you tell them what the consequences are if they don't, right? It doesn't have to be a threat, but it has to be a real conversation. So they don't walk away just going, oh yeah, had a conversation with my boss, and they don't understand that it's a serious situation to you. The next step in the process, of course, is going to be a written warning. This is where I would say you want to involve HR if you have an HR department. You want to have somebody there probably as a witness just to make sure that there's no confusion later, right? If you are a man and you're bringing a woman into the office or vice versa, you might want to have a witness there just for other reasons as well. So there can be no misunderstandings about what happened or what was discussed. Now, I'm going to tell you from my point of view on a written warning, it can be done really one of two ways. One way is the traditional way, right? We have our written warning form, we fill it out, we check all the boxes. There's the threat in the bottom that if, you don't show immediate sustained improvement, you're going to be fired, all that kind of stuff. That's one way to do it, and it can be effective, right? But I will say that as I get older, maybe, and I have more experience, I've come to believe that sort of a more professional way of doing it, and certainly with professional level of employees, is to sit down and have the conversation and then document it after the fact, usually in an email or some sort of memo or something like that. You still want them to confirm receipt, right? But it feels less sort of, I don't know, paternalistic, condescending, whatever words you want to use, toward that person. It's more of a, professional peer-to-peer discussion. And just to say, hey, this isn't working, right? We really need you to change X, Y, and Z. Here's what I'm expecting. What do you need from me to be able to do that, right? You want to also make sure that you're building a case that you're referencing a prior warning. So you can say something like, you'll remember, January 15th, we had this issue come up and we sat down and we talked about it. And I told you then that we really needed it to change. This is another incident a month later. So we really need you to be on board because we can't allow it to continue to happen, right? So whatever format you want to use is fine. You want to just keep getting that point across. Here are the expectations. You're falling short in terms of your performance or policy violation or whatever it is. And here's what needs to be done about that. And here's what will happen if it doesn't get done. Okay. So one of the things I want to just remind everybody is you always want to include this phrase, failure to demonstrate immediate and sustained improvement may result in further disciplinary action up to and including termination of your employment. And the reason you want to include this is because you want to make sure they understand. Let's say, you tell people, hey, your performance needs to be at this level within the next 30 days. Is it okay if they wait until day 29 to kick it up to that level? Of course not, right? I mean, you need it immediately and you need it sustained. So we have this happen all the time where you sit down with somebody and you say, hey, you know what, you've been showing up late, you need to be here at 8 a.m., whatever the case is. And then for a week, they're great. And then what happens? They slide back and they start coming in at 8:10, 8:15, things like that. So you want to make sure that you're getting the point across that they have to show immediate improvement and they also have to keep it going. Now, I'm going to tell you that the next step in the process is not normally suspension. You will go back and look and note that it's not even on my agenda slide. And the reason for that is typically we don't use this, right? We used to, like when I was, baby HR person growing up, this was always the third step in the process. And pretty much companies have moved away from this and toward performance improvement plans, which I'm going to talk about on the next slide. So if you do want to go the suspension route, typically it's done because you're doing an investigation. Maybe there's a situation with harassment. We had this with a client a couple weeks ago where one of their customers actually accused one of their drivers of harassment, and we had to conduct investigation. And so, he can't drive that route until he knows. So, she can send him home and say, hey, go home, suspend him with or without pay, right? Until you know what the results are. If it's for harassment or something like that, and you find out, hey, there's no truth to this, then of course you want to absolutely go back and pay the person. Lynn and I were talking about this, when we were doing our prep, and we're both sort of of the feeling, go ahead and just pay the person to go home. You shouldn't be taking that long to do the investigation. And it also, you're not burning a bridge with them, but that's again, a company decision. You want to document the suspension like you would a written warning. So again, you're going to say, here's what happened, here's the, the expectation, here's what's going on, here's the gap. And then the other thing is, if you do want to send somebody home, don't make it a long weekend, right? Don't go like, oh, we're going to send you home for Thursday and Friday, we'll see you back Monday, right? That's a reward to most people. That is not disciplinary action. So as I mentioned a second ago, that step in the process sort of as a last step to let them know this is really serious. If this doesn't turn around, you're going to be fired. I would say you go one of two ways. If it's something that's performance related, right? They're just not doing a good job. Their quality's poor. They can't work fast enough, whatever the case is. Then I would say you want to go the performance improvement plan, right? You're going to give them really specific goals to hit. You're going to touch base with them regularly. You're going to make sure that you spell out any kind of support you're going to give them, things like that. If it is a policy violation or if it's attendance, then I don't think a performance improvement plan is really the right way to go. It's more of a last chance warning, another written warning, but this one you're going to tell them, this is your last chance, right? It's a final written warning. And if you don't turn things around, then we're going to let you go, okay? You want to make sure that you're going to involve HR on this without a doubt, right? Or your senior manager, whoever you go to in your organization, or if it's like an ethos or your attorney or somebody, but take this very seriously, right? You also want to make sure you're documenting what you've been doing all along, right? Make sure, okay, we talked on this date, we talked on that date, and now we're at this point in time, and this is it, right? So they're going to have to show immediate sustained improvement. Last thing about performance improvement plans or last chance warnings, a lot of times I've seen them written where somebody says, you have like 90 days to turn this around, right? we're going to touch base in 30 days or something like that. But if that person isn't showing immediate improvement, you don't want them around for even 30 days, much less 90 days. So you want to make sure your language is such that you're not boxing yourself in and committing them to employment for the next 90 days. So just make sure that at-will language is included in that, and that you tell them you're going to periodically check in, and that you want to see improvement, but it has to be immediate and sustained. All right, so a disciplinary action checklist, you want to make sure of a few things that, take a look and make sure it's an appropriate and also proportional response. So like I said early on, if it's something, workplace violence, falsification documents, maybe fighting, something like that, you're going to want to make sure that you're jumping right to more of a final written warning or even termination. If it's an ongoing issue like attendance and things like that, you're not going to go straight to termination. Unless, again, maybe it's in their first 90 days and they've missed, 5 days in a row or something. You're like, okay, that's it, we're done. You want to make sure you're consistent with your policies and practices. But again, that means similarly situated people, okay? Not everybody has to be treated the same way. That's the uniform part of this as well. So you want to make sure that you're being consistent and uniform with respect to people that are similarly situated, but it doesn't mean all people. Be objective about it. A lot of times I'll talk to a client and they'll say, yeah, the person was out last Friday. I know they, weren't really sick or whatever. Well, do you really know that? If they're saying that they're sick, you're going to take it at face value. Now, if they say they were out sick and then you go on Facebook and, they're at a party in Vegas or something, then you have some documentation to the contrary, right? But don't just attribute your meaning to something. Make sure that you actually are going based on the facts. Not a surprise means just that. Like the employee should understand ahead of time the consequences of their actions. If you've done your job, and I know Luna will touch on this during the termination conversation, if you've done your job, then there should never be a surprise. Like if you've set forth the expectations and they know what they need to do to be successful in that role, and they're falling short, this isn't a surprise to them, right? So you want to make sure that they're not shocked when they're getting written up or when they're getting fired in particular. And then timely, do not postpone this. So I can't tell you how many times we've had a conversation with a client that says, oh my gosh, this person, I want to fire them. We say, what's going on? Oh, they can't get here on time. They're always late. And then you say, okay, when did this start? And they go, well, pretty much since the time they were hired. And you say, when was that? And they're like 8 years ago. And you're like, oh my gosh. And you haven't addressed it until now, right? So you want to make sure that you're addressing this in a timely manner. So it's a good link to the infraction and to the conversation with the employee. It's not like 3 or 4 weeks later and they're like, wow, that ship sailed, right? So you want to make sure you're doing that. There are times, I will say, when you decide as a manager, you know what, this is really on terminations more than the rest of this, but you may decide, hey, I would fire this person right now. However, I can't for a very specific business reason. And again, this doesn't happen that often. I'm just throwing it out there so you can think about it. Document that if you've made the decision to terminate, but because of business decisions, you want to wait for a week, you want to wait for 2 weeks. Document that at the time the decision's made. Again, something that's time-stamped. Send yourself an email, send it to your HR consultant, send it to your attorney, whatever, and say, this is what we're going to do and why. And then that way, if it ever comes back to haunt you, at least you've done what you can to document the decision-making process. So again, what's considered documentation? You're going to have your verbal and written warnings, but it's also, to me, documentation is the at-will language that you have in hopefully your offer letters and on your application and your handbooks and everything like that. It's the standard of conduct that you have in the handbook. They're going to read the handbook when they get there. And that's, to me, that's warning, right? Here's our expectations of what good behavior and bad behavior looks like. So there's other things here. There's time cards, obviously performance appraisals, emails, there's so much more. So just make sure that you're collecting all that documentation. You're building it into everything in terms of making your case when you come to somebody and say, hey, I want to fire this person. Here's my favorite standard of conduct. We included in all of our handbooks. Luna told me she loves this too. I think she's going to start putting it in hers, but it's conduct which tends to destroy harmonious relationships with or among employees, vendors, clients, or the community. Now, the reason we do this is because this happens all the time where somebody's really good at their job. You know, she's your top sales performer, for example, but you know what? She cuts corners and she's putting the company in jeopardy because she's doing that, right? She's not, you know, crossing her T's and dotting her I's and things like that. Or it's he's, you know, he's really good at his job, but nobody wants to work with him. They don't like him. He's not a nice guy, or he's rude to people, or whatever the case is. So it's really used when you can't put your finger on a specific standard of conduct, like a policy violation. Now you have one that you can sort of use to say, look, this conduct is unacceptable to us. Okay, last thing before I turn it over to Luna to talk about terminations. I use this example a lot. It's from early in my career, but we call it the Sally lesson. This is a woman when I was the first time HR manager who had been with a company where I was working for about 10 years. She was African American. She was over 40. So she ticks a lot of boxes, right? Because of that, a lot of the managers that she had like were really afraid of doing anything. And she was really well liked by her coworkers. Her performance was okay, but she had really bad attendance. She would call out sick and she'd show up late and she'd leave early and everything. So a new manager came on and the manager noticed it right away. And she was a pretty strong manager. And she was like, Linda, like, I want to get rid of her, but I'm just so afraid that because everybody in the department likes her and she's been here so long, they're all going to hate me and everything. Well, we moved forward. Of course, she still had some coaching sessions with her. We moved forward and it ended up getting rid of her. But you know what happened? Like exactly opposite of what this manager, her name was Chin, expected. Chin thought that everybody was going to hate her, but all of the employees started coming up to her and saying, thank you. Thank you so much for taking care of this problem. Because they can see it too. The coworkers know what's going on, right? If somebody's always late, the coworkers know because they're picking up the slack, right? If somebody's making a lot of mistakes, they know. So I use this lesson because a lot of times managers are so fixated on the problem child, they forget how it's being viewed by everybody else. How are you being viewed as a leader if you're not willing to address this, if you're not willing to step up, right? What message does it send to your weakest employees? Probably that it's okay just to do this, right? What message are you sending your strongest employees? They're not going to want to stick around. They're going to leave because they're not going to have respect for you as a leader. So, you know, my point is just view this from the lens of all of your employees' eyes. You know, you're protecting the company, yes, but you also want to say, like, how is this, how am I showing up as a leader and how am I being viewed as a leader? So a lot of times that's my wisdom for managers to make sure you're looking at it that from that perspective as well. So that's my section. And with that, I'm going to turn it over to Luna.
Wonderful. Thank you, Linda, and thanks for having me back. One of the strangest things is that this has become one of my favorite topics to present on. So whenever I get a call from a client asking me, you know, what is your advice here? We have this employee, I want to let them go. Do I have grounds to terminate this person? The first thing I always say is California is an at-will state. All employees are deemed to be at-will employees unless something contrary is in play, for instance, like an employment agreement. And we're going to go through some examples where there are contrary statements or public policies that would change the at-will nature of this employment. What at-will status means is that the employee can be fired or can choose to leave as long as it is not done for an illegal, a discriminatory, or a retaliatory purpose. That's also a bit of a mouthful. The at-will language, it's actually statutory language, and it comes directly from this California Labor Code section, which says an employment having no specified term may be terminated at the will of either party on notice to the other. Employment for a specified term means an employment for a period greater than 1 month. So what you'll notice here is that that language says having no specified term, meaning if you're not wanting to create a term relationship between employer and employee, you need to pay attention to the language you're using in your employment contracts or your offer letters. And this comes into play in situations where you could hire a temporary person on your payroll. You'll want to make sure in your offer letter that you use language like approximately 3 months or for an unknown duration to be reviewed monthly. Don't commit to a term if you're wanting to keep this at will status of employment. We really drill down on including at-will language in both your handbook, your offer letters, and other appropriate documents so that employees acknowledge the policy multiple times. I also like to put a provision into handbooks and employment agreements that states that no one other than the president of the company can change the at-will status of employment so that we ward against perhaps managers who like to say things like, and this is Linda's example that I'll steal, as long as I'm at the company, you're here, right? So we really want to try and put some parameters on that. As I mentioned, there are exceptions to at-will employment, and the overview is on the slide there. What Marla Robinson, and if you do not know who she is the founder of our law firm and current partner in the transactional department. She is fond of saying that all terminations can be viewed on a riskiness scale. Some situations have minor risk on one end of the continuum. Some situations have moderate risk, while other situations should be considered very risky. So part of the conversation that you should be having with your HR consultant or attorney is the level of risk involved. And this is why when we get those calls, you'll see we start asking a lot of questions. What is the age of this person? Explain to me the series of events that took you to the point that's made you make this call to me. It is also important to keep in mind that as of 2024, we had SB 497 that went into effect. And what this Senate bill states is that there is a rebuttable presumption of retaliation if any adverse employment action, so demotion or termination, is taken within 90 days of the protected activity. So this presumption makes it easier for employees to prove retaliation because it is a presumption that you need to rebut, and it makes it harder for employers to defend themselves. Once retaliation has been alleged, you must provide a legitimate, non-retaliatory reason for the action that you took. And this is really where documentation becomes so important that Linda spoke about. Looking at how have I documented this? Has it been calendar slips on the date that I have issued warnings and all the various other examples that she highlighted? That Senate bill, it applies to a wide range of protected activities, including whistleblower retaliation and unequal pay allegations. And employers who are found guilty of retaliation, they may be required to pay a monetary fine up to $10,000 to the affected employee. So we're talking about a substantial sum of money here. Now going to look at all of these illegal reasons for termination in greater detail. And the first one that I'd like to chat about is protected characteristics. One of the exceptions to at-will is firing someone based on a protected characteristic, such as these listed on the slide. This list constantly grows. I feel like every year that we amend handbooks, we're adding some or other additional protected characteristic. So it is important to make sure that your handbooks are up to date, reflecting the most recent protected characteristics. It is a violation to discriminate against anyone based on a combination of these characteristics. So not only on one, but on a combination of these characteristics. And we had discussed that new change the law in our new laws webinar for 2025. I believe that was our last one that we did. That being said, just because someone has a protected characteristic or a combination of these protected characteristics. For instance, just because someone, and this is Linda's example, just because someone is a pregnant Asian lesbian over the age of 40, it doesn't mean that you are stuck with that person if she isn't performing. It just means that there is a greater risk, and documentation becomes even more important for the reasons that you are terminating this person. Next, we've discussed that you cannot retaliate against someone, and there's that rebuttable presumption. So what does retaliation look like? So firstly, if an employee refuses to commit an unlawful act, for instance, you tell them you're going to have to perjure yourself, or your employment ends and they refuse to commit perjury for you, or they refuse to violate antitrust laws, that would be regarded as retaliation if you then fire them for that. It can also take the form of performance of lawful acts and where they exercise their legal rights and then you terminate them. For example, serving on a jury, refusing to take a polygraph test, if they file a workers' comp claim, and if they complain about unsafe working conditions. If you go and terminate them after they have engaged in that lawful activity, this will be seen as retaliation. And then lastly, whistleblowing activities, reporting unlawful conduct. This is something that would be seen as retaliation. There are certain scenarios that are simply just riskier than others, and we'll have a look at them here, where someone has multiple protected characteristics, like we touched on. Let's say you're over the age of 40 and you're also disabled. You have a combination of protected characteristics there. If someone has a disability or a serious health condition, you need to tread lightly if you're considering terminating someone on those grounds, or certainly not on those grounds, but someone with those characteristics. If they are either on or returning from a leave of absence, if they've been complaining about working conditions or pay, that is a protected scenario that they're engaging in. And this last one has really sparked after, at least in the top of my mind, after you had to adopt a workplace violence prevention program. That's what that acronym is there. If you're faced with two choices, it's really a case of pick your lawsuit. Either you are potentially faced with a wrongful termination claim versus a claim by the other employees or an employee for failure to fire someone who has committed workplace violence. So yeah, that phrase, pick your lawsuit, you're going to have to make a judgment call there. There are also other concerning words such as illness, discrimination, harassment, hostile work environment, retaliation. When you hear these, it really does trigger the need to review everything very carefully. You should review everything carefully anyway, but if you hear any of those words, you really need to be on high alert. The way that we can ask ourselves the question, have I reviewed this very carefully, is utilizing the tool of a pre-termination checklist. And I will, in the interest of time, I'm not going to go through every point here, but if you can have a look at this checklist and really ask yourself these questions, just pulling out, did the employee give up other job opportunities to move or accept the position, or has my documentation been sufficient? Really have a look at these pre-termination checklists, which continue onto the next page here. And pulling out a really important one here again, is this employee a member of a protected class? Some other considerations that you need to take into account when you are considering terminating an employee is constructive discharge. What this is really the flip side of a wrongful termination. And this is where a manager or the company itself, it makes the employee's life so difficult at work to try and get them to quit. It's a cause of action that you can indeed be sued for, and you should make sure that your managers don't think they'll avoid a lawsuit by getting someone to quit. Having said that, we have come across several employees who want to leave, but they believe that they won't collect unemployment insurance if they quit. And generally speaking, they won't if they resign. However, sometimes there are mutually agreeable ways of parting ways with an employee that gives a reason that the employee can then collect unemployment insurance, and it may be a way to get them to happily leave. Having said that, though, do not commit insurance fraud, but there are truthful statements that you can use that could work in everyone's advantage. Sometimes you're at a place where you no longer need someone. And if you have a role, for example, where you have 5 employees and you need only 4, it may make sense to lay off the person who is your worst performer. Of course, you'll want to document your reasoning, but this may be easier and a less risky way out to lay this employee off. However, having said that, you should never just say that you are conducting a layoff if you, in fact, want to terminate this person for other reasons, right? Only eliminate the position if you can honestly say you do not intend or need to replace anyone in that position for at least 6 months to a year. Then lastly, my favorite counseling point here when exiting an employee is, have you considered offering this person some severance payment and having them release claims by virtue of a separation agreement? So this is where an employee agrees not to file any sort of claim against the company in exchange for certain consideration. Now, what that consideration can be, it usually involves a sum of money, so severance pay, but it can also be a continuing benefit at no cost, or allowing someone, for instance, to keep a laptop that they need. It has to be something, however, that they are not already entitled to. So you can't have them sign a release agreement or a separation agreement, and the consideration you're trying to use is wages owed. That's not going to stand. So this is a topic that we could at least have an hour to 2-hour conversation on. So I won't go into detail about the severance agreement or separation agreement. Let us move on to what you need to do on the day of termination. So here you need to ask yourself the questions. Who needs to be there? Where is this taking place? Generally, the fewer people, the better. Does this employee have any property of the company? You're going to want them to return that property to you. And a point that Linda made when we were prepping for this is she said to me, I probably had to fire or lay off over 1,000 people in my life. And the point that she has come to see is that you really reduce your risk of being sued when you treat people with respect and dignity. And one way of doing this is to allow them to feel in control. So for instance, when it comes to having them collect their things from their desk, she used the example of, do I parade this person down the hallway where everyone else is looking, or do I say, do you want to come back after hours to do this, or should I box things up and send them to you? Make them feel that they have some sense of control in an otherwise uncontrollable situation. So now we've come to the point where the conversation needs to be had. You are going to tell your managers, or if you yourself are conducting this termination, you say, I have made the decision to terminate your employment or eliminate your position in the case of a layoff effective immediately. And then the guidance that we really, again, drill down on is stop talking. Less is more here. 90% of the time you have done your job and you have documented performance or policy violations, and the employee will just say, okay. 10% of the time, however, they're going to ask you why. And it is always good practice to just come up with a short response that does not go into detail, something along the lines of, you haven't showed improvement in your performance, or you're not meeting the company's performance expectations. Really, the less you say here, the better. And you can then, if they just keep on and keep on, Linda always says, nothing I say to you here is going to make it better. So let's go on to reviewing the paperwork. And we will now review the paperwork. So what do you need to provide on the day of termination? You are going to need to provide the employee with all money due. That includes base wages, overtime, meal period penalties, unused vacation, and usually commissions. And however, unless they cannot be calculated yet, then they will be paid out at a later stage. But definitely seek legal counsel on that point. You are going to give them the DE 2320 pamphlet. And that's the California's Programs for the Unemployed pamphlet. This gets updated regularly, so you want to make sure that you are using the most recent version. The most recent was published in Jan of 2024. You can just get this on the EDD's website. You'll give them the notice to employee as to a change in relationship form. If you do not have a copy of this, please reach out to us and we'll be happy to provide one. You then give them the HIP DHCS 9061 form. This is a form that is required to be given to employees if you have 20 or more employees. And then if there are any benefits that are offered, you want to make sure that you're giving information about continued benefits, as well as COBRA notices or CalCOBRA notices, which generally you can work with your insurer to provide those to the employee. And with that, we are done. And we are going to turn it over to Denise to see if we have any questions.
Oh, thank you. If you do have questions, please type them into the Q&A section on the website, or at the bottom of the screen, I should say, because since we're on Zoom. That's a lot of information. I think a lot of people have been in situations where it wasn't done correctly and things got out of hand with employees. So I think this is really helpful. Do you have to offer severance? That was one of the first questions that popped up.
I'll take that one. No, you do not have to offer severance, but it can certainly be a tool that will mitigate your risk against claims. So you never want to, however, give severance payments if it is not in consideration for a release of claims. Always make sure that there's a release of claims.
Yeah, let me jump on that bandwagon. So we get this call a lot, right? And they'll be like, oh, I'm going to just give them a couple weeks pay, thinking like if I'm a good person, they won't sue me. Don't do it, right? You're just wasting your money. So let us help you, let Luna help you put together a severance agreement. It doesn't have to be anything, that's really complex. In fact, the simpler, the better, but at least something that's going to acknowledge that they're giving up their right to bring a claim against you in exchange for this severance. And you can get creative about the severance. It doesn't have to be a lot. It could be $500, right? Wouldn't you rather spend $500 and give the employee, maybe access to their insurance, pay their COBRA for a month or two? Wouldn't you rather do that than get sued and spend thousands of dollars on legal fees? I mean, I would. So but you have to do it right. There's rules around severance depending on if the person's over 40, and everyone has a certain amount of time that they get to review it. So you just want to make sure that you're playing by all those rules.
Great. So you mentioned people over 40. So what is the process? What process, excuse me, should employers follow if a position is being eliminated and the employee is in a protected class, let's say in her mid-60s?
Well, it happens, right? So I'll start this and then Luna can jump in. I mean, you obviously, like any kind of position elimination, you want to document the reason for it, right? Is the company, again, go back to the example Luna used, like maybe you have, 5 people in a position and you've decided you only need 4. The problem, the challenge is you have to look at it sort of in the rearview mirror, right? So let's say that that person who's in her 60s is the one that's chosen, but everybody else that remains is, like under 40, that's going to be a huge red flag to somebody, right? Because on the surface, it appears that it could be discriminatory, right? So it's like if you're Monday morning quarterbacking something, you turn around and you're like, oh, wait a second, we eliminated the one person over 40. That's a red flag. That could be the right answer, but you have to document the reasoning behind it. And that's where consistency comes into play. There's nothing in the law that says how you have to choose the people. It just says how you can't choose the people, right? So you can't choose somebody because they're Black, because they're over 40, because they're a woman, because of whatever. But they're not saying you can't do it based on seniority, based on performance reviews, based on some combination. Whatever metric you want to use to make the decision of who goes on list is fine, but you want to be consistent about it and you want to document the thinking behind it. And then you take a look and do that adverse analysis to say, hey, did we unintentionally even impact certain groups of people? Anything you want to add, Luna?
Yeah, just in the context of a separation agreement, if you do have someone over the age of 40, like in this case, you really want to make sure that you have an attorney look at the separation agreement that you're giving them, because there are different notice periods and like the amount of time that someone needs to be able to consider your separation agreement. I believe it's the Older Workers Protection Act actually requires you to give, in the case of a layoff, a employee over the age of 40, I believe it's 45 days to decide whether they are going to release the age-related claims. So make sure that in these nuanced situations where you are dealing with protected classes, that you are having legal counsel review your agreements.
That's great advice. Another question came in. If an employee is inconsistent with attendance, would you include suspension as a step in the disciplinary process? And then they said, or would you recommend going for a PIP? I think that's like a two-step question.
Yeah, I would say neither. I would say I would give them a last and final warning. Because here's the thing, you're saying that they have bad attendance, so you're going to send them home and take them off work for more days. Like that doesn't make any sense, right? You want to try to get them to work, not outside of work. So I would say a performance improvement plan is usually used, from my perspective, best when it's a performance related thing, not when it's attendance or a policy violation. But when it's an attendance related thing, I would just go to the last chance warning and just say, this is it. You know what I mean? And you can also put some other requirements around there. When you get to that point, they've probably already exhausted their sick pay from long ago, right? So once they've exhausted their California given, 40 hours, then at that point, you can also sort of impose additional rules, right? So it might be like, hey, don't do it in the first 40 hours, but after that, you might be able to say like, hey, you know what? You need to show essentially perfect attendance for the next whatever. And if you don't, you need to bring us a doctor's note that says you couldn't work that day, right? Or you need to bring us some other documentation, if something else caused you not to be able to work. So that's the route I would go. I would not go the PIP route or do a suspension, because I think that adds to the problem.
Yeah, same here. I really don't think that using suspension is a great tool here. And ironically, I got an email, I think a day or two ago about something similar. Employees tend to, when you send them home, have some time to think. And someone just went to the doctor and got a note that books them off for a month. So you really want to try and avoid situations like
Yeah.
that.
There's also all those lovely commercials from attorneys on air too, when they're watching TV. So yeah.
On air, on the side of buses, anywhere you go, billboards, there's all those commercials. Quick question, do we have to give the EDD pamphlet to involuntary and voluntary resignations? So does everyone have to get the EDD pamphlet?
Yeah, I believe it's a requirement to give it to everybody at the time of separation, as well as when someone was out on a leave of absence.
Okay. If an employee gives 2 weeks notice, is the employer obligated to pay it out?
I
No.
don't believe so, no. I mean, if they say I'm giving 2 weeks notice and you don't want to keep them for 2 weeks, because actually I don't always think that's the best course of action. They could do some damage in those 2 weeks. I just prefer, no, you're actually leaving today.
Yeah, there's no requirement to pay the 2 weeks, but EDD may view it as a termination now as opposed to like a resignation. So the difference being about unemployment insurance, right? So if you fire the person, now they might be able to go and apply for unemployment. But as I always tell our clients, don't let unemployment make your decision for you, right? Like you do what's best for your business, and then, EDD will make whatever decision they want to make. So if someone does give 2 weeks notice, you don't have to pay it out. And think about it this way. What if I came into you and I say, hey boss, I'm giving notice for 2035. That's when I'm gonna leave, right? Like you're not gonna pay them all that time, right? So it doesn't matter if it's 2 weeks or 20 years or whatever, you don't need to pay it out, but just be thoughtful about the consequences.
Um, can documentation include something like a note on a calendar, or does it always have to be on a form? So I think probably what best practices should they follow is really what we need to know.
Yeah, I mean, again, it depends on what step in the process you are, right? But if you're just having casual conversations with somebody, it's a verbal warning, it's a coaching situation, something like that. A note on your calendar is fine. I like things to be dated. So what I would rather do is send myself an email, something like that, right? Or forward an email to somebody, because that way it's time stamped, right? It's less likely to be challenged later, is my thinking. But yeah, just wherever you want to make a note, you could have a file like old school, like hard copy files. I used to keep a file for each employee, and I would drop things in there, good, bad, otherwise, right? Anything. So when it got time to write a performance appraisal, I didn't have to think back, what happened a year ago. It was right in my file. And then I could take a look at the whole year and not just have a recency issue, because I could remember the last month.
Okay. You covered this just a little while ago, but the question keeps coming in again. If a new hire is already showing performance issues within their first 90 days, would you recommend the PIP process or the last warning route?
Well, again, for performance, you could go a PIP, but if they're in their first 90 days and they're not hitting things, I would go back to, were they the right hire to begin with? Do they need additional training? I would step back out of the, progressive discipline thought process for a second to say, okay, wait a second, what happened here? Maybe we as the company, it's, like, I'm sorry, but we made a bad decision, right, in hiring this person. Maybe they were great BS artists during their interview. There's a whole bunch of things that could happen, and you've hired the wrong person. And honestly, there's a saying, be slow to hire and fast to fire. And that's what I would say. If they're not doing their job or you're seeing red flags in the first 90 days, don't spend a lot of time going through this process with them. Think about whether additional training or support would help them. If it's a performance issue, if it's attendance, I would get rid of them. They're showing you who they are early on. It's not going to get better. Think about that. You just hired this person. They're in their first 90 days. This is the best they're ever going to be, right? And if they're not showing up, I would just get rid of them.
I'll just add to that. I had a call also fairly recently with someone asking, can I let go an employee who is still in their introductory period? And if you have at will employment, absolutely, but just make sure that when you are offering them in your offer letter that employment, or you're using an employment agreement, or then in your handbook, when you're defining what an introductory period is, and make sure you're not using the word probationary, it's an introductory period, that you are inadvertently not saying that they have term employment for that amount of time.
Yeah.
If an employee gives 2 weeks notice and you don't accept the 2 weeks notice, does it change the termination from voluntary to involuntary?
Yeah, if you walk them out, if you don't pay the 2 weeks, anything like that, that's the risk you're taking, right? Is that now it becomes an involuntary situation. But honestly, usually it's only for that 2 weeks, right? I would say if the person walks in and says, hey, I'm giving you notice, my last day is going to be, a week from Friday, it's a Monday, right? Something like that. And you don't want them to stick around, that's fine. But I would get it in writing from them, accept their resignation, right, for 2 weeks out. You could pay the 2 weeks and then it just stays as a resignation. Or if you're gonna just say, nope, thanks, I'll take today as your last day, that's fine. But then EDD may view that as a termination and award unemployment benefits, but it should only be for 2 weeks, right? Because they were gonna quit. So that's why you want to get it in writing as well.
There's a couple of different questions on excessive absences, which seems to be a problem in so many cases. If
Yeah.
there are excessive absences where the employee is claiming they are sick and then they are constantly turning in doctor's notes, is there any legal repercussions if you ask them to file for FMLA?
Wow, that's a whole topic that I'm not sure we want to go down that rabbit hole on this one. Yeah, let's not tackle that one right now, Denise. That's like we have to like really unpack that one. There's a lot of different levels to it.
There actually is quite a few, and so a few people did write in and ask about templates. I asked them to please contact you or Luna directly if they need a template, if they need to discuss a termination, if they're unsure of what steps to take. I think the best thing to do is to reach out to the both of you. Um, just one last question, because I know we're hitting 12 o'clock. Again, we will download the questions. We'll try to get back to you. The webinars will get posted. Is a change in relationship letter different than the termination letter?
Yeah, I don't even know what a termination letter means, right? That's not something that we use. We use this notice. And Luna and I had a conversation about this because we're both in agreement, the less said, the better. We never offer, there's nothing in state or federal law that actually requires you to tell the employee why they're being fired, believe it or not. It seems counterintuitive to me, but there's nothing in there that says that. So on the notice form, it just has the boxes. You check which box and be done with it. If you've been having the conversations you should have been having with that employee leading up to that separation, again, they're just going to be like, okay, and there's not going to be anything else to do. But we never write a letter outlining like the thinking behind it, because all you're doing is locking yourself in. And if it does go to litigation, that's exhibit A. So I would say definitely not. I know we're at 12 o'clock or right past it. Just wanted to say thank you to everybody for attending. Thank you to Luna for sharing your expertise, and Denise, as always, for moderating. Here's our next webinar. We are going to try because I'm not sure the limitations, but we're going to try to do a fun Kahoot game and teach everybody some labor law things, which is test your knowledge and have some fun. So hopefully you can join us on March 20th. More details will follow, but the link to register is right there. So on behalf of Luna and Denise, thank you so much for joining us today. And we hope you have a fabulous rest of the month.
Thanks, everyone.
Thank you, everyone. Bye.